3, 2, 1, start. A perusal of the order of punishment dated 25th May, 2006 reveals that the disciplinary authority had imposed the punishment on the basis of a surmise to the effect that the theft of the steel crossing sleepers would not have been possible without the petitioner's connivance. Stop para. It is well settled that suspicion, however high may be, can under no circumstances be held to be a substitute for legal proof. Stop para. The disciplinary authority, had penalized the petitioner on the basis of an alleged fault on the part of the petitioner to prevent theft, coupled with connivance on the part of the petitioner. Stop. The allegation of connivance does not feature in the charge sheet, and a perusal of the inquiry report also reveals that no evidence was laid to establish any allegation of connivance against the petitioner. Stop para. The inquiry report nowhere refers to any evidence which links the charged officer with any offence of connivance, and that as such the findings of the disciplinary authority to the effect that there had been a connivance on the part of the petitioner is absolutely perverse. Stop para. As the disciplinary authority was of the opinion that the theft would not have occasioned without the connivance of the petitioner, he could have remitted the case to the inquiry officer for further inquiry and report in terms of the provisions of the said rules of 1987. Stop para. The accusation of connivance had been a factor towards determining the punishment, though the petitioner was not given any opportunity of hearing to deal with the said accusation, and such error in the decision-making process maligns the impugned order of punishment, and the same is, accordingly, set aside and quashed. Stop para. A perusal of the appellate authority order dated 28 December, 2006 reveals that the petitioner's contention in the appeal petition had not been considered and the order of punishment had been simply affirmed. Stop. The said order reveals no independent application of mind on the part of the appellate authority. Stop. The said order is also not supported with any reason. Stop. Rule 217.3 categorically provides that the appellate authority should consider as to whether the procedure prescribed in the said rules of 1987 had been complied with, and if not, whether such non-compliance had resulted in violation of any constitutional provisions or in miscarriage of justice, and as to whether the findings are warranted and based on evidence on record. Stop. But the order of the appellate authority does not reveal that the said provisions of the rule 217.3 had been complied with. Stop. Such infirmity in the decision-making process renders the impugned order of the appellate authority to be unsustainable in law, and the same is, accordingly, set aside and quashed. Stop para. It is further a trite law that an authority empowered to pass an administrative order which causes a civil or evil consequence against another, must pose unto himself the correct question so as to enable himself to be acquainted with the relevant facts, failing which such action must be held to be a misdirection in law, and in the instant case the imposition of punishment, without following the statutory provisions and by travelling beyond the charge itself, constitutes a blatant infirmity in the decision-making process. Stop para. For the foregoing reasons, the impugned inquiry report dated 17th April, 2006 issued by the respondent number 5, the impugned order of punishment dated 25th May, 2006 issued by the respondent number 4, and the order dated 28th December, 2006 passed by the appellate authority being the respondent number 3 are hereby quashed and set aside, and the respondents are directed to grant the admissible service benefits which have been denied to the petitioner pursuant to the order of punishment, within a period of 8 weeks from the date of communication of this order. Stop para. However, since the charges remain, the disposal of the writ application will not prevent the respondent authorities from proceeding against the petitioner on the basis of the same afresh, in accordance with law. Stop.